We're back with Bruce Olson, president of ONLAW Trial Technologies, with part 3 of our series on electronic and computer forensics evidence. And Bruce, the next question I have for you would be, what steps should a lawyer take to ensure electronic evidence is not altered?
Well, the first thing you need to do is make sure that if a computer is turned off, that you don't want to boot it up. Just the process of booting up a computer is going to alter information. Another important thing to know is not to access files, because simply by opening and accessing a file, you're changing metadata information that relates to that file and altering it in a way that is permanent, and you can't go back and get the information that you wanted unless you're using appropriate preservation techniques to avoid these types of changes.
And, you know, I think one question that runs through a lot of attorneys' mind is the cost of e-discovery a barrier for law firms to properly manage e-discovery?
There's no question that e-discovery has added a significant layer of extra cost to litigation today. But by the same token, almost all business is now conducted using computers and creating information in electronic format. So it's unavoidable. And the problem that we face, because we're using electronic information and because of the volatility of the information, you need to take the appropriate steps to preserve it as early as possible. And so you need to bring in the appropriate experts to help you out at the beginning of any situation that you are concerned may lead to litigation.
So the costs do come into play. I guess the next question that most of us would like to know is there any way that an attorney can control the cost of e-discovery?
Well, first of all, if the attorney gets to the problem early enough, many of the problems that result in the horror stories, expensive horror stories that you hear about, can be avoided. If you follow the rules, if you get the people who know what they're doing helping you out, that's the first step to making sure that you keep the costs down. The next thing you want to do is understand what you're asking the expert to do, have an engagement agreement that specifies what they're going to do and what the cost will be, and fine-tune it as best you can in order to have an understanding of what you're dealing with.
So we talked about this briefly in an earlier episode, but I want to come back to the timing question that we had talked about. You know, is there a benefit to being proactive and thinking about e-discovery early in the process? I mean, does that have anything to do? Is the timing really that critical?
It really is, because the case law puts an obligation on you to preserve information, as I mentioned, as soon as there's a reasonable expectation of litigation, and that can start long before a summons and complaint is filed or you receive notice of the start of a lawsuit. So you need to go in and take the appropriate steps to preserve the information. The attorneys who represent clients now have affirmative duties that require them to understand the computer systems of the client, to meet with the appropriate people, to put in a litigation hold to help preserve the information, and to make sure that they're periodically renewing and reviewing and renewing the notifications of preservation of information. The failure to do that can result in sanctions against the client and potential malpractice cases against the attorneys later on if they fail to live up to their obligations.
Well, Bruce, thank you for taking the time to talk to us about electronic and computer forensics evidence. This concludes our 3-part series on that very topic. Tune in for the next episode of Practice 411 Fastlane, and thanks for watching.